Chairman Wontumi, the new lawyer, a friend of Akyea, Abusuya, or the plan tactics be na ya exposing a big time. Our hosider, Abusuya, and Mguasi Chinchinchi, Aka lawyer Akyea, just say. The case no cramp no ye handy over a demand no. Indeed 2 days and I say indeed 3 days. Lawyer Akyea afa a dream be say yes I had July judgment no final judgment na ye de ebre Wontumi no abusuya e say ono no obeji case no why na adwen say opese or arrest judgment no and one of the top lawyers no be Ghana ha nensema or can say case ne de say ya conclude case no e kwan a lawyer Akyea abefa so bia opese or the arrest judgment no enya dia ebefa na asem we Wontumi say lawyer e de asem etu ja no why shocking abusuya sa omo tactics ne omo plans ni nyina eliki ama court no asan so expose Akyea enye asem keto akra ye bepese e be me yakọ na yakọ akoti lawyer ye frɛ no Enusafo seni na answer na be kɔ no on subscribe na hit on the notification bell so na be any update be drop no on so on sa ebetumi akabi na Ghana has say open computer papa and a laptop papa na we use the abura parliamentary computers and accessories and I'll be your laptop papa na we using the location no enye irakwan o Kumasi Buokrom Estate Eli friend number ya egu e screen so 0247 030108 and I say 0597942133 parliamentary computers and accessories and a laptop papa and a computer papa or the ede bako woman say ukra low budget and a high budget ubenya high quality laptop parliamentary computers mommy corner yenkonkuti and some course
on the hope judge no man judgment.
Oh sir,
yes.
Even if there is no representation of a counsel for the accused,
the judge will just record that there was no representation.
Oh,
that's what the judge will record.
Counsel say what fun lawyer for and then a memoir explaining now lawyer now what fun of what effect could it be? We better be arrested judgment and now be
No, he will just try. It's just I don't know the strategy, but he will try to arrest the judgment. But on to me, the horses are bolted. It's a little too late to do anything about the judgment. The case is closed. So judge know a certain time frame within which to give the judgment. The case now as far.
Wow.
Yeah, no, it's finished.
By he gave an indication, sir, he will call for the proceedings. Now, whereby the court erred in the proceedings, of course, no idea, and no want to be in the matter say be obetimi in our jurisprudence no obetimi the akwadan be a higher court or a supreme court for interpretation of a beer more rules be obetimi.
Oh, that will be a matter for on appeal. Maybe the judgment no year and then the proceedings of the court is made available to Akyea. No of her proceedings and then there's a procedural breach. And now there is a fundamental rule of breach of natural justice. And now the judge took into consideration what he ought not to have taken into consideration. And such things. And now there was no really offense found against the accused person. But the judge went ahead to pronounce. So there could be many grounds, but that will be after the judgment.
After the judgment?
Oh no, but I guess now the case is closed. There's a time, you see, this criminal jurisprudence. So that's why everybody is saying that, mostly jurists and lawyers are saying that criminal case, we should find a time to expedite action. Because some decide if I don't call court, oh yeah, I did. I mean, it potentially infringes on his right. Until let's expedite action and try to finish the case within a reasonable time. Okay, clarity committee, okay.
Aye.
And the time limit for criminal criminal trials. In fact, they were so convinced that a criminal trial should not go beyond 6 months. Yeah, because you see, why you will be, we see why you're born, or is that born? It should not be a trial and error matter. It's because there's a prima facie case says you're born, and that's why you are trying that person. So why should it take more than 6 months? So that was why Clarity Committee said, no. This thing should be, unless you are fishing. So that is why I believe that if Akyea Kubi had reasons to withdraw, he should have withdrawn before the closure of the case. We have three witnesses in one leading evidence. You have been cross-examined and you have closed your case. Now close your case. How can it be opened again?
Oh. I say one case ni koso nyina through all the trial, cross-examination, whatever. No, one ma bontia me complain the behavior of the trying judge. Nemum a call ya a call we na or bekan we.
No, I never know. You say you're training. You're training. The case is done in the court and not in the public domain. You see, politics na amma lawyers be brave. Omuko court we are. No muka asam the SC court. But you training say, we a lawyer. You have to do your case in the court, not in the court, not the court of public opinion. In the law court. So, but the judge no ye adid the emphata. There are remedial steps. Law no ankasa emma lawyer remedies. Because someone say judge no nipa. Nti motumi ye adid the emphata. Nti law no ankasa emma remedies. It is not as if to say that there are no remedies. There are remedies. So one take advantage of the remedies provided by the law to correct those things, those idiosyncrasies of the judge. Now, as some we know about Abakase, oh, judge na yet, yes. Then, I mean, to what purpose will it serve? To what purpose? And in fact, if you take steps in court to bring to the attention of the judge now on own personal idiosyncrasies there, who are ankasa who doing who say affecting case no, those will be recorded and to be on the record. So, until if you are convinced that those things no are affecting the trial, the impartial trial, the fairness of the trial, that could be grounds for appeal. That could be grounds for appeal.
Council, back one complaining and another and the Akyea could be a complaining say the case was highly expedited. Just say that walk around back court no lead counsel never can say, oh, your case was what cousin your case was over time bear so be a mapon bear 2 of us. Oh, okay, and about 3 amumra was it a hina sadi. Was it a do baby crana who said Sadiana trial judge was alien to our jurisprudence?
No, it's not alien. Let me see. That is the judge's court. And he is responsible for case management. Say introduction who care about case management.
Yo, pa.
Also, yeah, evaluation. Where judge no? Evaluating. So he has to do a certain number of cases and complete within a certain period of time for his evaluation.
Oh, promotion, Neboa.
If we can say promotion, we see evaluation.
And I mean,
that's his court, and this is how he wants to run it. Because ultimately, you can't pander to your whims and caprices. Because no court, no court, no court, no lawyer, no court. It's the judge's court. So you can't dictate to the judge how to conduct the cases in his own court.
Oh, sanity.
That's why when the judge says that, come not, and you say, oh, ask my Lord, please. One is
program bebre.
Yes. Okay, so
I see.
I don't know why you say
Council, my additional kakra. You say your case is as good as your lawyer. Sadie no correct.
No, no correct. No correct. You see, you're training, no. Sometimes your case is good, but your lawyer doesn't know the procedure, and then he messes up the case. Sometimes your case is not that good, it's a borderline. Your lawyer knows the procedure, he knows the pitfalls, he appreciates the weaknesses of your opponent's case. And then, in the criminal matter, for instance, it's about the ingredients of the offense. The ingredients of the offense. Say we hear live soup. A day they would hear live soup, no. A different from a day they would hear bunu. So if you cook live soup and say that this is bunu, I as a lawyer should tell you that no, these ingredients are not in the soup. So you can't, the offense will not be made out. The soup will not be made out. You understand? So offense beer, crime beer were ingredients. So as a defense lawyer, I want to see whether the ingredients have been met. And not only met, that there is proof beyond reasonable doubt. So in all submission, I tell you that the defense lawyer in a criminal matter is just to raise doubt. You're just to raise doubt. Immediately you raise doubt, that doubt is to the benefit of your client. But you must conduct the case in its totality. That's how it is done.
I can't mean say what it is and be say. Galam say yinya chama Wontumi nkuna ye kase nkrofo ye. Why should he be singled out and then put on the legal chopping board?
Prostitution, nipa bakuno ye prostitution. But some have done it, they have never been arrested. Some have done it, they have been arrested. Armed robbery, nipa bakupe no ye. Money laundering and scam 419. Nipa bakupe no ye.
It might be a syndicate.
There might be a syndicate, and some will even escape the syndicate. When you are arresting them, some will escape.
Yes.
That's how the law works. But the long arm of the law will catch up with the people. Tell what you want to be freer. The Wontumi will not be no longer in the equation. Yes, sir.
Huh?
So it means that the next person will not be Wontumi. You understand? That's how the long arm of the law works. Why you need free? In America, it's different. In America, their jurisprudence, they would have taken time to see all those people connected with Wontumi, including those who are sitting in Accra and those who are sitting in offices. And then when they are arrested, they arrest all of them. They break the syndicate. But we pick the people who, I think it's part of the difficulties in investigation and the time. Because, yes, some people are doing it, but they'll be arrested. If the law finds them, it will arrest them. Yeah.
Now, a council back where we must send an other case a Exim Bank case. Now, Nipabia, you say, oh, what call Exim Bank and one more Makoye business and a loan no and one samwaba. It's other civil, civil procedure, echo swore on Exim Bank din no esa be ye criminal matter na kodu safe Wontumi kura say woma criminalizing kura dia wate na wo be go for plea bargain within the civil and then the civil matter and then the criminal matter no eba ni say kon bebre ye ntiase ye ni aye ni mrei
what the lawyers attack the fraud vitiates everything. What is that?
Yeah, fraud vitiates everything. Yeah. Mm-hmm.
You can't put something on nothing.
Yes.
It won't stand. What could you loan? Now, crater there, who could you loan in a forge papers? Can the loan stand?
Daddy.
Good. So the Mukasano, they're just taking one part of the case and talking about it. I'm not saying that Wontumi case is that, but I'm saying that you can conduct a matter in a civil setting, but that will have criminal underpinnings.
Okay. Let's just say Criminal and Other Offences Act in 101 no crab to me a juma defrauding by false pretense.
Defrauding by false pretense, it's a civil matter. It starts with civil. We say we say America. Me say mbetima bua wa kwa America. Na me say we say mbua wa for $2,000 bra. So that's a civil. Me say tam je kano. A civil arrangement. Yes sir.
And it's a council.
Some de ukasano. Wouldn't him say one year ambassador, 1 year counselor, 1 year Juma embassy. Wouldn't need to me to send that person to America. Carter there would be fun of America. Nina, yeah, forge papers.
So you are promising what you can't give.
That's defrauding by false pretenses. Because the promise is fraud. And the fact that you say you can do it, it's a false pretense.
Wow. Any NHS and some pow council. Now council, me who adie bia me yema hye kakra. Minerals and Mining Amendment Act in 2019, Act 995 no. Waka offenses and penalties. Now section 99 will say a person who buys or sells minerals without a license in accordance with section 682, 97 or 104 or a valid authority granted under this act or any other enactment commits an offense and is liable on summary conviction to a fine of not less than 10,000 penalty units and not more than 15,000 penalty units and to a term of imprisonment of not less than 15 years and not more than 25 years. We are not doing the
Oh, I won't tell you how it came about.
Catch me, council.
That was Parliament. Mrs. Navika said, no, but I still remember the person who changed the present tense. I know. That you are talking to me, I'm just seeing the person's face in my eyes. The original, that was when MPP was in office.
Oh.
The amendment, it came when MPP Nana Akufo-Addo. And the Attorney General did not bring the penalty, the original draft, the bill, it didn't come this way. But
original draft never say
a lower sentence.
Hey.
But that time na galamse a problem. That was the time the galamse was a problem. So I told them, I warned them that if you are targeting a problem and you are targeting the specific problems with specific acts, you might end up passing bad laws. The one here.
Because my way to a year session 99 2 no or say a person who without license granted by the minister undertakes a mining operation contrary to provision of this act. B. Acts or instigates command, counsels, procures, solicits, in ordinary manner purposely aids, facilitate, encourages, or promotes any acts in contravention of this provision act, in respect of which a penalty has not been specified, or contracts a non-Ghanaian to provide a mining support services, commits an offence, is liable to a summary commission to a fine of not less than 1,000 penalty units and not more than 15,000 penalty units, and to a term of not less than 15 years. They will be close mining. Mi busuani no no na waba na mi tu ne fo se one ye oba mine de asiska wo obetini akoye ana say ye masase oba na se koye wo de koye chi na ya ka ho asem ya koye ni na no ana ma instigate ye yiro ho ya omuka se jai ko nyai yo ni na no fa ye wo ma me no no ano den
wa facilitate wa encourage wa support
commande solicite instigate hey papa,
so they have made it a
could you call it a bad law?
They have made that thing a felonious offense. Now, well, that was intended to frighten people. Now, it was only say law itself is also to get people to understand that it's a high risk activity. Until we will cook them for more than 25 years. By which time, if you are 30 years, by which time you come out, you will be an old man. So you bow out on Pununo. So that was the intention, to make it deterrent enough. But said the Amikaya when I was in Parliament, the enforcement bit, even say 5 years, is the enforcement that is important and not the sentence. Who can say at the Ministry of Lands and Natural Resources, Nana Kofado Benso. There was an officer at the Ministry of Lands and Natural Resources. He was accused of facilitating the Ukai. Because of sentencing and because he was sympathetic to the government. When you are there, under defrauding by false pretenses.
One of the Criminal and Other Offences Act, no?
So that they will give him a lesser sentence.
It's not less than 10 years, so a year penalty.
Yeah, but they give him a lesser sentence. So it's not less. They give him a lesser sentence.
Oh.
Not defrauding by false pretenses. They said, Okaka say Obama Obi Atasi to Galamse, to this when he had no authority, to good when he had no authority. That falls under the Section 99. But Omunim said, 1, he was working in the office. 2, sympathetic to the government. 3, sentence no yet thing. So that is what law does when you pass it with an intention to implement it. Because when him say, Lord, it will be a bad law, it will your own comfort. So you have to balance the requirement for punishment with reasonableness.
Because when sentence near can was the penalties thereof. Where you to be found?
That's the penalty. That's the sanctions. These are the sanctions. So you limit how it is drafted. They have limited the discretion of the judge.
At this threshold, now bet him the partum, but copy this ceiling.
So the Oman band, but even the floor level is high. The floor level of the band is high. And just like we say, Ubuswani, who offers to say Okotuma, Wakanchiro, even telling him not to go and do it, so Kachiro, and there is evidence that we are Kachiro, and not telling him not to go and do, and keeping quiet, you will be an accomplice. Because
me Amasimio was counseling area ha de one say boys anu omo wie school wo nyina mining anu omo ye nti so
Okay, abusuya we ne ensema yekọ so political highway so lawyer Akyea na HSN go ase aka na secret plan of person or the borem court no elikia ya exposing a big time. Every time I say some of Japan kokoti sa ensem we edimai.